So thank you so much, everyone, for being here. It is a big pleasure for us to have, to be able to have in this seminar to Visa Kurki. Visa Kurki is Associate Professor of Jurisprudence at the University of Helsinki, institution where he is also the director of our center, or Helsinki Animal Law Center. But also in 2023, he was awarded an ERC project, our European Research Council project, starting grant for 1.5 million euros. And the project is called Agency in Law. But also, previously to that, Visa completed his PhD in 2017 at the Faculty of Law of the University of Cambridge with a doctoral dissertation on legal personhood. Dissertation that was awarded 2 prizes, the York Prize by the Faculty of Law of the University of Cambridge, and also the Sargent Medal from the College Clare Hall. And as many of us we know, the dissertation has been published by Oxford University Press in 2019 with the name A Theory of Legal Personhood that has been key for many of us for developing our projects in animal law. So in addition to that, in addition to legal personhood, Visa's interests include animal law, rights theory, and social ontology. So Visa, thank you so much for this presentation, and the floor is yours.
Yeah, thanks so much. I'm now going to try to change the camera so you can see the Christmas tree behind me. There we go. So thanks so much, everyone, for being here. It's nice to see so many of you here in person and online. So the paper you're about to the presentation you're about to hear is also a paper, a written paper that I hope to submit quite soon. It's still a working paper, so I definitely welcome all comments. I've entitled it "Why Animals Already Hold Legal Rights." So basically, the background of this paper is that I thought when I was doing my dissertation, actually, that I had this novel idea that actually animals already hold legal rights as a matter of contemporary sort of law, that as a matter of positive law, there is nothing further we need to say that animals already hold legal rights. I thought it was being original. Then it turned out that some people already said that in the contemporary discussions. But more recently, I learned that some people have already said that like 100 years ago. So this is one part of this presentation. I think another sort of a contextual point here is that the reason why I wrote this paper is because Saskia Stucki, who some of you might know, sort of provoked me that I should state my views on animals' legal rights more clearly. And we were going to be both speaking at the same conference in Cambridge. And I thought I'd frame it as a sort of that I criticize her positions in particular, because I thought it would be a fun argument that we could have. So if some of this comes across as me attacking Saskia in particular, we're actually friends. And I'm now trying to make it a bit more balanced, but it's nothing against Saskia per se. That's the sort of background of the paper. Right. So let's get started. Let's see if I could maybe like this. So this paper, I'm not going to say more about this, and Marcia already graciously introduced the project. I'm just going to say that this is not exactly, this doesn't have that much to do with the agency law project, actually. It's just been sort of a side project, but we have this agency stuff going on and so on. But so here's the rough talk structure. First, I'll give a bit of an introduction about how current animal law theory and legal theory more broadly views animal rights. Then I'll provide a brief intellectual history of this sort of a thin rights way of thinking about rights. Then I'll defend this view, and then I'll briefly talk about whether legislative and judicial language matters if I have the time. But as an introduction, so here are just a couple of things or examples you can think about to make this more concrete. So let's say that we have a law that says dog owners should legally give food and water to their dogs every day. So then we can ask, do the dogs hold the right to food and water every day? Similarly, if a law says cows should be stunned before slaughter, can we say that the cows hold the right to be stunned before slaughter? This is sort of the debate in current animal law scholarship. That can we already say that animals hold right as a result of these kinds of welfare laws? And there are roughly two positions in current theory. So one is that animals do not currently hold legal rights because they are not protected strongly enough. So the laws that protect them are so weak, or because the law has not given them rights explicitly, or because they're not legal persons, or because they cannot demand their rights. I think these are the four main reasons. And if you sort of hold this position that animals currently don't hold legal rights, I would say that you are in the majority. This is sort of still the traditional and the sort of paradigmatic view of animal rights. But there is this sort of alternative position, which is that animals already hold some limited legal rights because even weak protections can entail rights. The language of animal protection statutes is not relevant, so it doesn't matter whether the statutes talk about rights, because one can hold legal rights without being a legal person. And this is something I've discussed before, but I'm not going to emphasize this point here. And then instead of the sort of demand view of rights, rights are about interests. And this is sort of an alternative view. And I used to think it's a novel view, but it turns out it's not. And we'll get to that in a moment. So there are roughly, I would say, three types of debates that are pertinent here. One pertains to the nature of rights, so whether we subscribe to the so-called will theory of rights or the interest theory of rights. One has to do with legal personhood and subjectivity. So do we view legal personhood as something that's a precondition for holding rights, or do we view it as more like as a result of legal rights or something else? And then there's a question of what I've here called types of rights. So there are like different types of rights, and are all these types of rights sort of sufficiently robust to be legal rights stricto sensu, at least. And this is the discussion I'll mainly be focusing on. I'll say a little bit about this discussion as well, but I won't be focusing on the legal personhood thing that much. A couple of caveats. So legal welfarism is the view that or the type of protection that animals currently receive is under a so-called welfarist regime. And I'm not trying to defend that regime. I'm just trying to examine it. So that's one thing. And secondly, there will be a lot of white men. So I apologize for that. And this is still work in progress. I'm happy to hear all comments, even though, as said, I do hope to submit this quite soon to a journal. So here it comes Saskia Stucki, who a couple of years ago published a seminal article, at least in sort of the animal law sphere, where she made a distinction between what she calls simple rights and fundamental rights. So simple rights are the kinds of rights that animals supposedly hold as a result of animal protection laws, and fundamental rights are something more robust. They protect fundamental interests, according to Stucki. They are not easily infringible, and they come with certain procedural benefits, such as standing, so you can enforce them in the animal's name normally. Another recent contribution to this this sort of distinction is by Raphael Fasel and Sean Butler from Cambridge. So in their textbook, Animal Rights Law, they make roughly the same distinction, but they call these types of rights thin and thick rights. And I'll say a bit more about thin rights in a moment, but thick rights, according to them, are, or a thick right is complex and made up of a set of held legal positions. It protects individuals' fundamental interests. It has a high threshold for justifying limitations. It is directly enforceable by the individual or their representatives, and it has a dynamic character, allowing it to enhance its protection over time. So this is roughly, we talk about constitutional rights, so that would be a fundamental rights. And the question is, if some entity, such as an animal, doesn't have thick rights, only has so-called thin rights, can we still say that the animal holds rights? And then the basic idea of these simple or thin rights then is something, it's that when we ask whether an animal holds a right, we make a very simple exercise. So we look at do we have duties towards animals that benefit animals? And if we do, then we apply the so-called interest theory. So do our duties benefit animals? And if they do, then the animals hold a right. I mean, there's a lot more in the background, but this is like a simply put the basic idea. So it sort of forgoes all of these questions about whether individual fundamental interests are protected and so on. I will get back to that. So even though Stucki, who I just mentioned, so she in a way introduces the simple fundamental distinction into the animal law scene, though I should say I'll say a bit more about that shortly. But she actually, even though she sort of presents the idea of simple rights, at the same time she doesn't really endorse the idea, except in a sort of a lukewarm way. So she writes, for instance, while theorists can show that a rights-based approach lies within the bounds of a justifiable interpretation of the law, an actual valid legal right hardly comes to exist by the mere fact that some theorists claim it exists. And there are substantive reasons for questioning whether the kinds of rights extractable from animal welfare laws are really rights at all. So even though she sort of offers the label simple rights and helps our thinking in that way, I think she still seems to treat fundamental rights sort of the primary type of rights. But what I hope to show here is that this sort of a thinner idea of rights has a long history, and these kinds of rights are an established type of rights as well. And here I found quite helpful David Brink's recent paper where he makes a distinction between two types of rights. And this is quite close to actually what Stucki was just saying as well. So according to Brink, both in law and philosophy, there are two different ways of thinking about rights. So one is what he labels contributory rights. So this is the kinds of rights that we use when we engage in legal reasoning, legal interpretation, and so on. I'll say a bit more about that in a moment. And then we have conclusive rights, which are the kinds of rights that are a result of legal or moral or other type of normative reasoning. And so let's look into this distinction a bit further. So contributory rights are inputs into normative reasoning, whereas conclusive rights are conclusions of debates about the entitlements of individuals. And if this sounds a bit strange, we'll shortly have a couple of examples. But so contributory rights are especially important contributory factors that typically control the resolution of the practical situation in which they are present. Whereas, according to this conclusive view, the central role of rights in normative argument is conclusory. People argue toward rights, not from them. This is John Overdyke's definition or account. So in philosophy, if you have rights-based accounts of morality, for instance, this is usually where you have a contributory view of rights. And in law, normally, when you talk about constitutional rights or human rights, that's where you have a contributory view of rights. So you're using rights in your argumentation to get into some kind of a conclusion. But you can also have conclusive rights in law. So you have all kinds of statutes, decrees, constitutional provisions. They don't necessarily even talk about rights, but you might still end up having a lawsuit where a court has to say something like, okay, so the correct interpretation of these statutes is that person A has right to something, for instance. So this is a conclusive view. It's the end result of the legal debate in a way. And we use rights, the term right, I think, in both of these ways. My sense is that this contributory view has been of more interest to for instance, people working in intellectual history, so people who look at history of human rights and the rights of man and those kinds of things. So they're mostly interested in the history of contributory rights. But this conclusive view, I think, actually has an intellectual history of its own. And I'm, of course, not an intellectual historian, but I'll try to say a little bit about this now. This idea of thin or simple rights has, according to me, a long venerable pedigree. and I'll look at sort of two different developments here. So one was happening on the British Isles with people like Bentham, Mill, Austin, and so on, presenting this view of rights. And another sort of development was happening on the continent, with especially some scholars such as René Mogg and Al Frost being inspired by Rudolf von Jherin's interest theory of rights. And we'll look at both developments shortly. And I should mention that it's quite interesting that some of these also explicitly discuss animal rights, which is a bit surprising. So Bentham, as many of you probably know, was not just a moral philosopher. He was also a legal scholar and a jurist, but he had a view of rights, which I think is very close to this simple right way of thinking about rights. So he wrote in 1789, "To know how to expound a right, carry your eye to the act which in the circumstances in question would be a violation of that right. The law creates the right by forbidding that act." So if, for instance, the law prohibits assault, the law prohibits us attacking each other, the law simultaneously also creates rights. We simultaneously gain the right not to be assaulted if the law prohibits us from assaulting each other. So this is a very, very simple view of rights. At least the sort of animal lawyers in the room are probably familiar with Bentham's sort of an important position in animal ethics. So I thought I'd just say a little bit about that, because when I was looking into this, it turns out that the result was a bit surprising, because even though Bentham has this famous line where, what is it, it doesn't matter whether they can think and blah, 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 but if they can suffer, and then there is this reference to slavery, and I don't know, I don't remember the exact quote, but I found an interesting paper by Johannes Knies, which shows that actually Bentham's animal ethics was much less radical and quite modest, actually. So this is Johannes Knies's sort of characterization, or sorry, it's yeah, I mean, so it's partly Knies and partly Bentham. So animal suffering is justified whenever it serves a useful purpose, for example, in the way of food, physic, clothing, conveyance, or manufacture, as part of experiments to promote medical or other useful knowledge, as way of chastisement, or to defend any person or thing from being hurt or annoyed. So animal suffering is basically almost always justified. And it's a bit sort of discouraging, because Bentham is considered one of the forefathers of the animal rights movement, actually. That he had such a lackluster ethical views in the end. But we're now interested mainly in what he had to say about rights, in particular, animal rights. And in his old days, I mean, he was something like, he was definitely like about the age of Donald Trump, I guess, when he was still writing a lot, but this was sort of an unpublished manuscript, where he wrote that in a large sense, animals endowed with sensation are termed things, and those so termed in a moral sense may be said to have a right to be well treated. So here is sort of a welfarist account of a right. So there's a right to be well treated, insofar as it's consistent with the use which men have need to make of them. And the second part is a bit confusing, because on one hand he writes that in a legal sense, no such thing can be said to have a right, at any rate a right exercisable by himself, though by any man in quality of its guardian, a right may be exercised on behalf of the thing. So I don't know, it's a bit sort of neither here nor there, but I guess he's open to the idea that animals actually could hold legal rights as well. So another example from the UK is Henry Salt, who wrote, this is just a couple of remarks, but basically, and he was not really, he was more like a public intellectual. He was not really a legal scholar. I'm not sure if he even had a law degree, but in reference to the first UK Animal Protection Act, Salt wrote that it is scarcely possible in the face of this legislation to maintain that rights are privilege with which none but human beings can be invested. So he also seemed to think that an Animal Protection Act entails rights. I think the developments happening on the European continent are in a way even more interesting. So we have Rudolf von Jhering, who was a rather famous German legal scholar who presented an interest theory of rights, and Jhering actually briefly discusses animal rights as well, but he rejects the idea because he has this view that I call the strong rights or no rights position, which is that if animals were to have legal rights, then we would have to stop hunting. We would have to stop using them in all ways, basically. So he wasn't really open to the idea of animal rights as a result of the interest theory. But two continental legal scholars were inspired by him. One was René de Mogh, a French legal scholar who was mainly a private law theorist, and he wrote that already in 1911 that animals actually can be subject to private law. And I think that his writing is quite entertaining because he's sort of quite disparaging of the opposite view. And an even more interesting example is Alf Ross, and this was sort of a surprise to me, that in his second doctoral dissertation, Pia can help me with the Danish pronunciation, Virkelighed og gyldighed i retslære. So he says explicitly both that animals can be subject to private law and very explicitly that animal protection laws give rights to animals. So this was 90 years ago. And it actually, I'm sure like AI is good enough for translating that stuff right now today, because I think the discussion is very modern. Like there are these sort of modern arguments and counter arguments regarding whether it's appropriate to think of animals as having rights. But I should mention that Urpo Kangas here at the faculty was the first person who sort of alerted me to Ross's writings on these things. So thanks to Urpo. And then of course Ross's magnum opus on law and justice. So there's also a brief discussion of animals as subject to private law, but he doesn't discuss the sort of animal protection laws anymore. Just a couple more people in this sort of intellectual history part of the presentation. So some sort of Anglophone legal theorists from the 20th century, John Chipman Gray and H.L.A. Hart. So both have this kind of an argument that basically animal protection laws would entail rights for animals if animals could demand their rights or if someone would represent them. So basically they have this will theory view of rights. So the problem for them is not that these rights are simple rights in the sense of being weak rights, but rather that they don't come with the right kind of enforcement mechanism. So for instance, Gray writes that so the interests of brute animals may have legal protection, yet beasts have no legal rights because it is not on their motion that this protection is called forth. And Hart actually, he says two things that are relevant. One is that he propounds a very clear conclusive view of rights, if you still remember what a conclusive view was. So he writes that A has a right, like he is out referring to like a game, I'm not sure what game, is therefore the tail end of a simple legal calculation. It records a result and may well be called a conclusion of law. So this is clearly a conclusive account of rights. And then a couple of decades later, Hart writes that the will theory, which was his theory of rights, provides an explanation of the fact that animals, even though directly protected by the duties of criminal law prohibiting cruelty to them, are not spoken of or thought of as having rights. So again, animals would have rights if only they could demand their rights. So the problem is not that they are weak, that's not the problem, but the problem is something different. And in the sort of more recent Anglo-American discussion, there's been plenty of people who have made similar kinds of arguments. So here's a couple of scholars who think that animals already hold legal rights. Well, McCausland is maybe a bit of a special case because her argument is more like a moral philosophical one, I think, or political philosophy. So Stuckey writes, and this is, well, I'll get back to that in a moment, but she writes that classifying animals' existing legal protections as rights may conflict with the deeply held view that because they protect interests of special importance, legal rights carry special normative force. And I'm a bit skeptical whether this actually is a deeply held view. So do they really have to protect interests of special importance? That's not apparent in most of the sort of views I've just presented. And also they actually might protect interests of special importance. I'll say more about that momentarily as well. But to summarize, so we have sort of a thin rights tradition as a sort of counterpart to the sort of a thick rights tradition, which is more like a tradition of human rights and those kinds of rights, and more recently animal rights. And according to this tradition, rights are simple correlatives of duties, and the way we discover legal rights is by engaging in legal reasoning and reaching conclusions about the content of the law, and then considering who or what is protected by the law. And of course, it's not as simple as this, but at any rate, rights don't need to protect important interests. They can also protect trivial interests. And actually, I think one of the issues with welfarism, this type of animal protection, is that trivial human interest trumps central animal interest. So in a way, it's apparent there as well that law sometimes protects trivial interests with rights. And now I'll say a bit more in defense of thin rights. And as said, this is partly like responses to Stucky, but also some other people, but you know the background of why it's been structured this way. I've been trying to make it more balanced, as said. So one thing that's often said about rights in general is that rights single out interests that are not to be sacrificed to the utilitarian calculus. So we have some rights that are so important that regardless of whether useful it will be for the society, we don't have to give those interests away. And that's what having a right means. This is like according to the thick view, the fundamental view of rights. But to me, that's far from obvious, because it seems that some rights actually are results of social calculi of interests. So just to give one example, we could at least imagine that the right to daycare could be such a right. So it would not be justified because of this fundamental interest, but rather by things like we want more women to the workforce, we want more tax revenue, and these kinds of things. We could still say it's a right, but it would not be justified by this in this manner. It would rather be justified by the utilitarian calculus. So that's one thing. And then if we look more specifically at the types of thin rights, and this is where sort of the skepticism both Stucky, but also Gary Francione, who is one of the sort of classics of animal law theory, I suppose, is that there are like two types of protections that law accords to animals. So one is, so this is a quote from Stucky. So one type of protections have a narrow substantive scope, protecting highly specific secondary interests, such as a relative right to be slaughtered with prior stunning. And then there's these broader provisions, like which say something like an animal should not be subjected to unnecessary suffering, but they are watered down very significantly in practice. So Stucky mentions two examples. So there's what she calls the right to be slaughtered with prior stunning, and the right of chicks to be killed by fast-acting methods such as homogenization or gassing. And she then writes that while these rights may protect certain secondary derivative interests, such as the interest in being killed in a painless manner, they are simultaneously premised on the permissibility of harming the more primary interest at stake, such as the interest in not being killed at all. And I have a number of responses. And by the way, like, Francione in particular has very similar arguments. But I do have a number of responses. And these are, one has to do with the description of the rights. The second is that Stucky has very sort of gruesome examples, and that might affect our intuitions about this. And the third is how she describes the interests. So the first point is quite minor, but I'm sometimes a bit bothered by this in this context that Francione does the same thing. So if you have the right to be slaughtered with prior stunning, that means that someone has the duty to slaughter you, and it's a good thing for you to be slaughtered. But that's not the right that you have. You have the right not to be slaughtered without prior stunning. Okay, that's a that's a different thing. But for some reason, people keep putting it in this way. Second thing is, and this is also a relatively minor thing, but the examples are, you know, how you should be killed, for instance, and it's quite gruesome, right? But at least like in Finnish law, you could also talk of this example: mammals and birds kept as companion animals have the right to constant access to water. I mean, that sounds a bit nicer, right, than than this other example. So I mean, the choice of examples here may affect whether we think these are rights or not. But then there's this third issue, and here is where I'm sort of still trying to develop my thinking. So I've been tweaking with the paper very recently on this point. So Stuckey claims that the protected interest here is the interest in being killed in a painless manner, and this is what she labels a secondary interest. But one thing is that I think this is just a matter of phrasing, but it's quite clear that the interest here is interest in being killed, because that's probably not the interest you have. Rather, the interest is something like, if you are killed, you have an interest in a painless execution or something like that. You only have an interest in being killed in a painless manner if your life is not worth living, and that might also, of course, apply to some factory farmed animals. But anyway, but here I've been thinking about the sort of distinction between sort of fundamental and primary interest, and then sort of secondary or derivative interest. So let's suppose that well-being is one of our primary interests. So and then we have secondary or derivative interests. So well-being, we have some kind of an interest in well-being, whatever that means exactly, but something like that. And it seems that primary interest sort of entails certain kinds of derivative interest. And in fact, it entails an endless amount of derivative interest. So these are the kinds of interests that sort of, in a way, result from the primary interest. So you have if you have the interest in well-being, then you probably have the interest in not being punched, except in maybe some contexts, such as if you're a boxing match, and purely have the interest in not being in pain, and so on. There are all kinds of interests that sort of result from this primary interest. And I would suppose, and I'm still thinking about this, but I would suppose that the relationship between primary and secondary interest is a justificatory relationship. So basically, the primary interest justifies this secondary interest. So if you ask me, like, so why is it in your interest not to be punched, I would probably give you the reason that something like, you know, if we keep on having this discussion, like why, we probably end up in something like, I just have an interest in well-being. Like that's the end of the discussion in a way. So that's roughly how I think it's a justificatory relationship. So it doesn't work the other way around. It doesn't work that if I say that I have an interest in well-being, it's because I have an interest in not being punched. That's not the way the justification works. But I'm happy to hear your comments on this. Now, it seems to me that if we now take the example of this tick case, so we have a legal provision that says roughly chicks may only be killed by fast-acting methods such as homogenization or gassing. So quite clearly, it seems that it protects an interest, which is something like not feeling pain as a result of slow-acting methods, something like that. This is, of course, a very sort of a weak interest in a way, or very secondary, but it seems clear to me that it protects this interest. But it seems to me that at the same time, it also protects the primary interest. So that's how it always seems to work to me. If you protect the secondary interest, you also protect the primary interest at the same time. It's hard for me to see how you could only protect a secondary interest without protecting a primary interest. I don't really see how that's even possible. But of course, the protection of the primary interest is much, much weaker. And then I think what both Stucki and Francione and also Faso and some other people writing on this point out is that the protection of life here is very, very weak. Like if it's basically nominal. I mean, if you can only be killed by fast-acting methods, it doesn't really protect your life. So I grant you that life is not really protected here. But it seems to be that the fundamental interest in well-being is protected in a bit stronger way than life. So I would say that welfare risk protections do protect primary interest, but just very imperfectly, like in a very weak manner. But this is also the case for many of our human interests. Very often our primary interests are protected quite poorly by the law, in fact. So I think I some time still. So just to give you sort of I'll just show you quickly this. So we first went through narrow welfare rights, and then they also, both Stucki and Francione also discuss so-called broad welfare rights, supposed welfare rights. And here we have too many animations. So this is something like the right not to be subjected to unnecessary suffering. So both Stucki and Francione are quite skeptical of these kinds of supposed rights. Stucki writes that if the object of such rights, although the object of such rights is of a more fundamental nature, the substantive guarantee of these facially fundamental rights is to a great extent eroded by a conspicuously low threshold for permissible infringements. And Francione writes that a right to humane treatment is a right to have treatment evaluated under the anti-cruelty statute and to have animal interest and human interest balanced. And I don't necessarily disagree on this point, but I have a minor disagreement on how it's presented. So if you remember that Hart had this view of conclusive rights, that A has a right, like he is out, is the tail end of a simple legal calculation. It records a result and may be called a conclusion of law. So this is how I think the simple rights normally work. You have a statute that says something like it's prohibited to afflict animals with unnecessary suffering. Then you engage in legal interpretation, and then you get some kind of a result. And the result actually is something much more modest than what the statute might give away. So the result is something like animal suffering is prohibited in certain narrow contexts, C. So the statute looks pretty good, but the end result is something more modest. And that's where the correlative right comes in. So it correlates with the norm and not with the statutory text. So the right then would be something like right not to be subjected to suffering in context C. So I think it can be misleading to construe the statutory text as the right directly, but rather it's the text after interpretation. So this is like roughly how I would put it. I have a bit more to say about it in the paper. And then finally, there are other types of welfare risk protections that I think neither Stucki nor Francione addresses. So one example is that Finnish law doesn't prohibit fur farming, by the way. Many other countries prohibit fur farming, but Finnish law has this so-called positive list. So only certain species of mammals and birds may be used as production animals. So basically, no other type of animal may be used as a production animal. And I think that's a pretty significant restriction of their use. And if you think of wildlife law, there are often even more wide-ranging protections. And if you now take Robert Nozick's idea of site constraints, because quite often when people talk about rights, in a stronger sense at least, they mention this idea of a site constraint. So this is the idea that site constraints express the inviolability of others in the ways they specify. These modes of inviolability are expressed by the following injunction: don't use people in specified ways. So it seems to me that these positive lists also meet this criteria site constraints, because the law says don't use these mammals and birds as production animals. So that is an application of the site constraints. And furthermore, I think some of these are probably relatively well enforced as well. So if you imagine, for instance, that someone in Finland would start a dog meat farm, for instance, I'm pretty sure that would be enforced. Like basically, that would be get shut down very quickly. So it seems to me that dogs, for instance, probably have relatively well enforced site constraints as a matter of law. And then, so I've here sort of tried to argue that whether that animals already hold rights, and it doesn't really matter whether statutes talk about animal rights. So I'll just say a bit more about that. So does it matter whether the legislature or courts talk of animal rights? So I would say that it's not a necessary condition for the existence of these rights, because legislative and judicial language is often very inconsistent, and I'll give you an example shortly. And sometimes they don't use the term right, for instance, because it's sort of obvious that they don't need to. So here's just one example, the Finnish Tort Act. When it talks about personal damage, so the damage done to your body, for instance, that's in the language of rights. So one who has suffered personal damage has the right to blah, blah, blah. But property damage is framed in a different way. Damages for property damage shall cover the blah, blah, blah. And I don't think this is meant to entail, for instance, that only personal damage is sort of protected by a right, whereas property damage would not be. Here's another example, our Animal Welfare Act. So, because the act is sort of a mess, to be honest, from a sort of a certain point of view. So on one hand, the act states, for instance, when discussing this principle of respect for animals and intrinsic value, it says that this principle would not make the animal into a subject of rights, but then the same preparatory works states also that if legislation were to protect only the right to privacy, the authority's ability to oversee compliance with animals' rights would be weak. So the same preparatory work actually also talks about animal rights. This was spotted by Veera Koponen, by the way, so kudos to her. So even our sort of the primary Finnish animal welfare statute is sort of inconsistent. So I'll just say briefly what role I think legal language can play here, because I've now been sort of downplaying the role of legislative language, but I think it serves a purpose, definitely, but it's not an existence condition for rights. So one thing legislative language can do is chip away at this sort of a person-thing dichotomy. So if the law just starts talking more about animal rights, I think that will reflect maybe this kind of a way of thinking about personhood and thinghood, which I personally prefer, and I think which is better for animals, for instance, as well, and more descriptively accurate. I think also if the legislature were to talk of animal rights explicitly, judges might take the language of rights more seriously. So if we have the same example here again, that we have a statute and then we have interpretation, so this might lead to this kind of a norm. But if the statute said that animals have the right not to be subjected to unnecessary suffering, this might lead to a broader type of norm. Like the application of the norm, the resulting norm might be broader than the narrow type of than the interpretation of the statute that doesn't talk about animal rights. I think that's at least possible. And then more broadly, I think law has a symbolic effect on the society more broadly. I don't know, this is maybe a bit of an old example, but in 2013, there was the French gay marriage law, which passed in the parliament, and there were huge protests against it, that I think for it as well. But at that point, as far as I know, they already have like a civil partnership, which was almost equal in terms of the legal effects. So it was mostly about the question of legal language. And one final example, and then I'll finish. So So I've been using this example of a habeas corpus trial as an example of how, whether we talk of animal rights as something already existing, how it can affect the interpretation. So, or the argumentation more broadly. So if we think that animals currently don't have legal rights, and the habeas corpus is, so there are the North America and Latin America mostly, there are these cases where lawyers have argued that non-human animals have the right to a personal freedom and they should be released from the confinement from a zoo or whatever. So if the lawyers frame this as that the judges are granting the animals their first right, so they're currently things, they don't hold any rights at all, but they should now receive their first right. This is a very big decision for a judge. You know, they are supposed to now make a decision on whether to end this millennia-old division into persons and things and so on. And then you have these sort of quasi-philosophical debates about whether animals are the kinds of beings that can hold rights and should they then hold duties as well, and those kinds of debates. But if we say that animals already hold legal rights, it's certainly still a big decision that the courts are faced with, but it's not as big. So the question is more focused on should these animals also hold the right to habeas corpus. So the question is not whether animal rights, but rather what animal rights. And I've started calling this the emancipatory effect of talking of simple animal rights, because it sort of emancipates us from having certain kinds of arguments. Right. Did you want to take a picture of it?
Thank you.
Right. So I think this is my last slide. So this idea of simple rights has a long pedigree. Some scholars applied this idea to animals already in the 19th and early 20th centuries. And I don't see any obvious reason why this sort of fundamental rights conception would be more important from theoretical point of view. I'm not saying here that the current types of simple rights are not enough for animals. That was the point of the argument. It was more just to get a better grasp of what these simple rights are exactly. And I think also we humans have all kinds of simple rights that are often imperfect in various ways as well. So that's it. Thank you.
Thank you so much, Visa. Thank you. And it was fantastic. And please